Hi, my name is Marta Delgado, and I'm an attorney and co-founder of Delgado Rompf Bruen. I'd like to offer some practice tips to help you determine how the legal advice you give your clients may impact their ability to remain in the U.S. lawfully. Illinois has a growing community of immigrants. It is estimated that 1 in 7 residents of the state of Illinois is foreign-born. Consequently, it's important to recognize that even the best legal advice can impact clients differently depending on whether they were born in the U.S. or are immigrants living in the United States lawfully or unlawfully. Immigration status can also be a determining factor in how your clients decide to move forward with the legal strategy that you've proposed. Depending on an adjudication, disposition, or charge, those outcomes can greatly impact your client's ability to remain in the U.S. lawfully. There may be situations where you've determined that you've obtained the best legal result for your client because you were able to obtain a reduced charge to a misdemeanor offense or obtaining a sentence that didn't result in any jail sentence at all. However, even seemingly minor offenses, such as small possession of narcotics or minor theft offenses that did not result in any loss or minimal loss, can nonetheless have a detrimental impact on your client's ability to remain in the U.S. lawfully. In addition, not recognizing the legal impact that your client's immigration status can have on a disposition that you've obtained for them can also have unintended consequences for you as the attorney of record, and you may end up facing disciplinary action for having provided ineffective assistance of counsel. In 2010, the U.S. Supreme Court decided in Padilla v. Kentucky that an attorney had in fact provided ineffective assistance of counsel when he had failed to advise that the guilty plea could result in deportation proceedings against his client. As you meet with clients and determine how you want to move forward with your legal strategy, it's really important to start with the really basic question: where were you born? If your client was born in the United States or obtained U.S. citizenship, then your inquiry regarding immigration status doesn't have to go any further, because U.S. citizens cannot be deported. However, if your client's immigration status is anything other than a U.S. citizen, then you have some additional questions to ask. Where were you born? What is your status in the United States? Are you here lawfully or unlawfully? What kind of visa do you have? How long have you lived here? Have you ever been a victim of a crime? Knowing the answers to these questions can help your client figure out if they have any sort of relief to fight any effort to have them removed from the United States. The bottom line is, if your client's immigration status is anything other than U.S. citizen, then any disposition that results in an adjudication or a finding of guilt may have severe and negative consequences for your client's ability to remain in the United States. It's also important to know that an Illinois disposition of supervision is considered a conviction for immigration purposes that can be used against them in removal proceedings. Be aware that immigration status has to be a factor that you consider when you are giving legal advice. By asking just a few questions regarding your client's immigration status, you can determine whether the advice that you are giving is complete, or whether your client should seek the advice of an immigration attorney before the resolution of a case. In this manner, your client can understand the full impact of the choices that he's making to move forward with the resolution of his case, and you have some level of protection against charges of ineffective assistance of counsel in the future. I'm a member of the ISBA International and Immigration Law section. To learn more about this or other sections, please visit the ISBA website.